Against the background of the International Women's Day celebrated recently, Law Weekly speaks to a senior advocate of Nigeria, a successful arbitrator, and a well-celebrated professional, Mrs. Dorothy Ufot. She shares with us how she's been able to break barriers and challenge the status quo. And as part of agenda setting for the new chairman of the Economic and Financial Crimes Commission, another senior advocate, Ebunolu Adegboruwa, has made a call for reforms in the commission. He would like to see the EFCC free from political influence so that it can work independently and fearlessly. We also have our recap of the top trending stories from the courtrooms. Hello and welcome to the program. I'm Shola Shieli. It takes a lot of guts and courage to pursue what one really wants. And one person who knows this too well is my guest, Mrs. Dorothy Ufot, SAN. Against every contrary advice, she went back to school to study law after a first degree in political science. That decision to study law, backed by a strong determination, has propelled her to heights many are still desirous of achieving. She obtained a BSc in political science in 1983 and an LLB from the University of Lagos in 1988. In 1996, she got her LLM also from the University of Lagos. She was called to the Nigerian bar in 1989, and 20 years later, in 2009, she was admitted to the INA bar as a senior advocate of Nigeria. Mrs. Ufot also sits on the boards of a lot of reputable companies, locally and internationally. She's listed in the International Who's Who of commercial arbitration lawyers, recognized as leaders in the field of international commercial arbitration. She shares with Law Weekly how she's achieved all of this and more.
My first shot would be that we've made some progress. Things are not as bad as they used to be. We've shattered many glass ceilings. We just finished a webinar where the Deputy Secretary General of the United Nations addressed us by the Dangote Group. And one takeaway that I had from that is that the glass is half full. We need to fill the other part of the glass. And asking me about my story as a woman, I'm not going to deceive you that it has been a tea party. It hasn't been a tea party, but it has called for a lot of determination and hard work. And looking around and asking yourself, where do I want to be? In my own case, I did not set out to be as quote unquote successful as people think I am today. I just had a mindset of excellence. I set out to be a lawyer, and I determined to be a successful lawyer.
Because I saw that you read political science first.
Yes, but I reminded myself that originally your main plan was to be a lawyer. So I had to go back to school all over again to read law. And when I was in my first year in Unilag, I saw people who were younger than me, and I was almost intimidated, asking myself, are you sure you're doing the right thing?
What am I doing here?
What am I doing here? From the day I entered the class in Unilag, I realized that if I've taken the decision, by the way, I was discouraged, starting from my parents, because I had met my husband, who was then my boyfriend, before I finished political science. And typically, the whole idea was, you found a young man who has also finished his own school, so why don't you settle down to start a family? So I went back to read law against every advice. I finished Unilag in 1988. I was called to the Nigerian bar in 1989, and immediately there was only one ambition: to work with a son. I was fortunate. I was taken on by Mr. Harry Afolabi Ladna, one of the best lawyers that this country has produced. He took me on, and I spent 5 years there, seeing the respect that he was given in court by lawyers and judges, I determined that I will get to that high point. So I started my career on a note of determination. Along the line, I got married in the University of Lagos. So everything I have done or achieved as a lawyer has been as a married woman.
A few days ago, you were celebrated by your state government, not only as the first female SAN in Akwa Ibom State, but also as a professional of many firsts. And that brings me to my next question. All the hats that you juggle, wife, mother, career woman, leader, mentor, how do you balance it all? Is there any secret?
I will not pretend that it has been easy. It also calls for determination. Now, on the International Women's Day, we had a webinar from the Chartered Institute of Arbitrators. And one of the questions that was put to me was, can you have it all? Career, marriage, and children. And many women had different views. I think I was an exception. And I said, yes, it's tough, but you can have it all. Now, how do you have it all? You just have to prioritize. You have to be determined. You have to focus. I call it, when I am mentoring young women, I call it excruciating focus. It's not an ordinary focus. Excruciating focus. That's my normal language in talking about this. Because you see, the things that militate against women, in my experience, and I had that at the back of my mind from the day I decided to be a career woman. What militates against women? For instance, as a lawyer, people will be reluctant, particularly in litigation, people will be reluctant to instruct you for a big case as a married woman. Why? Because they feel you're going to come with excuses. My child was sick. My husband didn't let me stay out late. You know,
which is a normal part of everyday life of a married person.
Yes. If you want to aspire, you must not allow anybody say, oh, you know, women, they come with all sorts of stories. So what am I saying? Once you have made up your mind to combine the role of career, wife, and mother, you just have to be prepared. You cannot let the client's case suffer because your child is sick or because you have to cook. And in all of this, even as a son, I still go to the market, I still cook, and I still have time for...
You play all those traditional roles.
I play all those. I love cooking, personally. And what has also helped is a very supportive husband. And such people should be congratulated. And I implore most men. You see, I think it's unfair to stop a woman's career because she's a wife. If the husbands lend a helping hand and the women earn the trust of their husbands, I think women can combine. It's very doable. I have done it. I have two children, and both of them are very successful.
Let's round off talking about alternative dispute resolution, because I know arbitration is one of your many core passions. You're an internationally renowned expert, and you're also an experienced litigator, so you see both sides. Why do you think it is difficult for ADR to be fully embraced in Nigeria by litigants and even lawyers to settle local disputes?
The greatest challenge of alternative dispute resolution in Nigeria is the parties agreeing to comply with the results. And so the challenge is that in Africa, in Nigeria, people now see ADR largely as a first step to litigation, which is very unfortunate. You see, in the advanced countries, an award is delivered, you lose. Once the process has been conducted, with bearing in mind fairness, the rule of law, and all the things that would make challenging an award, because the parties and their counsel are there. They see the way the process is going. And automatically, because they have signed to resolve their dispute by this private mechanism, they understand what it entails. So the moment an award is published, the loser complies, issues his check.
They accept it easily.
And they accept it easily. But in Africa, in Nigeria, one of the biggest challenges is the enforcement of that arbitration award. And so you find that people are now beginning to think, should we really go into arbitration? Personally, I've been trying to enforce 2 awards for over 2 or 3 years now.
What makes it difficult to enforce?
Because you have to go, if there is no compliance, you have to enforce through the court system. And once you venture into the court system, you will take the entire run from High Court to Court of Appeal to Supreme Court, which is unfortunate.
Really saved any time.
You've not really saved any time. And people are now propagating, do we need a special ADR court that doesn't follow the usual, appeal system? What some jurisdictions have done in that they have, in their laws, they've incorporated an appellate system within the ADR mechanism, that if you lose and you are dissatisfied, another panel within that institution, mainly institutional arbitration this time, another panel is set up, made of different experts to review what has been done. And that is the ICSID system, which I have found to be very good, in that you avoid the courts completely. So, and the decision of that panel is final. So it's quicker. So I feel very strongly that if we have this, put in place this appellate system, not appellate system as within the court, within the arbitration process, where a different panel reviews what has been done, and the decision of that panel is final, I think it will go a long way to assist us in ensuring that arbitration is not a first leg of litigation, which is what we find now. Another problem that litigants have, you see, as an example, you're going into a contract with Shell. Shell has standard arbitration clauses. None of those multinational companies will go into any contract, no matter how small, without an arbitration clause. They've been doing it. They understand it. What I find with our local companies, when you talk about local content, the fact that Shell, Mobil, Ajip is willing to do business with them is fantastic. They don't go the extra mile to ask someone, please vet this contract for me. I agree that in many occasions, there's nothing you can do about it, depending on who the stronger party in the contract is. But at least I tell people, even if you cannot do anything about it, understand what you are going into, and understand that if a dispute arises, this is the way we're going to go. You can hardly find an agreement today that does not have one form of dispute resolution. People are shying away from the courts. Our judges know the rules now. So when these cases go to them, if you've signed an agreement that has an arbitration clause and you go to court, if your opponent raises it without taking any steps in the case, definitely today I can assure you that the Nigerian court will send you to arbitration because that is what you have agreed to do. So we are at that level where our court system is arbitration friendly.
Welcome back. The Economic and Financial Crimes Commission, EFCC, needs to be free from political influence so that it can work independently and fearlessly. This is the view of a senior advocate of Nigeria, Ebunolu Adegboruwa. The senior lawyer commended the appointment and confirmation of Mr. Abdulrasheed Bawa as the chairman of the EFCC, but hopes there will be a lot more focus on intelligence gathering, as well as a reorganization that sees the separation of prosecutorial from investigation powers.
I think that the statement that the presidency has communicated to the average Nigerian is in terms of the respect to the agitation for young people to man very important institutions in the fight against corruption. The EFCC has come to be like the foremost institution for fighting that war, even though there are other agencies such as the ICPC and the regular police. And it's an organization that needs somebody who is agile, somebody who is young and vibrant. And I have had the opportunity to appear in proceedings where Mr. Abdulrasheed Bawa has testified as a witness of the EFCC. And I must commend his intelligence, his appraiser generally, and grasp of investigation activities. So quite very impressive. So I do commend the president in that regard. But I think beyond that, I believe that there's need for a holistic restructuring of that organization, starting with the separation of the prosecutorial powers and investigative powers. You know, because what obtains in the FCC now is that there are people who are investigators, who will investigate petitions, and then also draft charges, and then also follow up with those charges to prosecute. You know, so it creates the problem of conflict of interest. It creates the problem of bias, likelihood of bias, because in the course of investigation, the fact that a charge has been preferred means that the investigator has made up his mind one way or the other that there's a prima facie case to pursue. And so he pursues that case with such vigor that he doesn't want to listen to any alternative or plausible option rather than just securing conviction. And that is dangerous. And that's why you see that the energy in opposing bail for defendants probably outweighs the concentration on the main charges itself, as I've seen in most EFCC cases. So there is need for that separation. And then there's need for total severance of EFCC from political influence, because that is the bane of that agency, in the sense that, you know, people tend to have come to grasp to use the agency to settle scores politically, whereas we found in times past that, you know, people probably who have political ambitions are suddenly charged to court. People who have political ambitions are suddenly invited, you know, and others, you know, with similar cases are allowed to go free. So it's important to make that separation to ensure that the agency is independent and then is able to focus on the core mandate of detection and prevention of financial crimes. And then the other point about investing in intelligence gathering. The era of compelling suspects to make confessional statements is not helping the prosecution of anti-corruption war, because, you know, once those cases go to court, you then find that lawyers raise objections, trial within trial, and those ones will get to the Court of Appeal, go to Supreme Court, and before you come back, witnesses are tired, and you may not be able to get prosecution going again. So it's important to invest more in infrastructure, to get the method of gathering intelligence. Look at what happened to the case of Hush Puppy. There was no need to arrest him. For close to 4 years, the FBI were trailing him, followed him to Dubai, because most of these anti-corruption cases are documentary, bank statements, and the lifestyle of the person. So they were able to get 4 years of forensic monitoring. By the time they picked him up, it was not necessary to even contest the case against him. So that's what we should leverage upon to ensure that we develop the intelligence capacity and then reduce the issue of interference between the agency and suspects, beating them up, people making allegations of torture or extortion. It's of no need at all. It will not help the agency.
And on the home stretch, we bring you a recap of some of the activities from the courtrooms.
We begin with the report that the Supreme Court has affirmed the 10-year jail term slammed on a former governor of Plateau State, Senator Joshua Dariye, for alleged criminal breach of trust. In a unanimous judgment read by Justice Helen Ogunmiju on behalf of the 5-man panel of the court upheld the sentence passed on Senator Dariye by Justice Adibukola Banjoko of an Abuja High Court. However, the court quashed the second charge of criminal misappropriation of funds preferred against the former governor. Senator Dariye had in his appeal asked the Supreme Court to overturn the November 16, 2018 judgment of the Court of Appeal Abuja, which convicted him and sentenced him to 10 years for diverting public funds estimated at 1.162 billion naira while he was the governor. Still in Abuja, a federal high court has fixed the 17th and 18th of March this year for the Attorney General of the Federation, Abubakar Malami, and 10 others to appear before the court to testify in the trial of Mr. Abdulrasheed Maina, a former chairman of the defunct Pension Reform Task Team. The trial judge, Justice Okon Abang, had on Mr. Maina's request issued a subpoena compelling the AGF, a senior advocate of Nigeria, Mr. Femi Falana, and former acting chairman of the EFCC, Ibrahim Magu, and 8 others to come before the court on March the 9th, 10th, and 11th to testify for the defendant. On Thursday, March 11th, Mr. Falana told the court that although he had not been served with the subpoena, he heard about it and decided to come before the court out of respect. The senior advocate said that the subpoena will provide an opportunity for him to put an end to the needless controversy surrounding a property he never bought. Mr. Maina's first witness, Ngozika Uhoma, had on the 4th of March testified about certain monies and property recovered by the former pension boss and how Mr. Ibrahim Magu, to whom the properties were remitted, had allegedly sold some of the property to friends and associates, including Mr. Falana. The newly appointed chairman of the Economic and Financial Crimes Commission, EFCC, Abdulrasheed Bawa, says that the anti-corruption body has identified about 70 billion naira fraud in the fuel subsidy program of the federal government. Mr. Bawa made this known in an interview with journalists after testifying in a 1.4 billion naira fraud trial involving an oil company, Nadabo Energy, at the Lagos High Court, Ikeja. Although the trial predates his appointment as EFCC chairman, Mr. Bawa has been involved in the investigation of the matter, and with his testimony, he becomes the first EFCC boss to give evidence in court. The EFCC accused the first defendant, Abubakar Ali Peters, and his company, Nadabo Energy, of allegedly using forged documents to obtain 1.4 billion naira from the federal government as oil subsidy after allegedly inflating the quantity of PMS purportedly supplied. The defendants had pleaded not guilty to the charge. And we round off the report that the Lagos State Judicial Panel on Restitution for Victims of SARS-related abuses and other matters has awarded the sum of 7.5 million naira to a petitioner, Mark Nwadi. The petitioner had told the panel that in May 1999, after he had just finished his secondary school education, he came to Lagos to look for his brother. He said he was standing at Egbeda bus stop with his traveling bag alongside other persons waiting for a bus when a police vehicle suddenly appeared, stopped, and the officers began to arrest people. They were taken to the Idimo police station and asked to pay a bribe of 100,000 naira each. Because he had no money, he was taken to the SARS office in Ikeja and the bribe was reduced to 10,000 naira. When he could not come up with the money, he was paired with a suspected criminal, taken to court, arraigned, and sent to Kirikiri, where he eventually spent 6 years. The petitioner, who says he became partially blind as a result of the incident, says he developed hatred for the Nigeria police after his ordeal.
And that's our program this week. Don't forget that you can find these and past episodes of the program on our YouTube page. I'm Shola Shirley. Thank you for watching and see you next week.